begin the next case. I want to make sure I pronounce your name correctly. First of all, it's Estate of Felten. Is it Mr. Arato?
Correct.
Okay, thank you. You may begin.
May it please the court, counsel. Bullet casings are fun. Let's talk about no contest provisions in wills. I represent Kathy Felten, and Ms. Hess and I had the honor of trying the case to the district court. We're here today because of the enforcement following trial of Mr. Rex Felton's no contest provision that was in the will. It's our position that Ms. Felten, Kathy Felten, meets the current test as it is to the extent that we can unravel it, but would also urge the court to maybe look at the test again and clarify what exactly is needed and or simplify the test. But no matter what the court does, obviously it's our position that Ms. Felten meets the standards. Under a totality of the circumstances approach, if that were to be adopted, I think that simplifies everything because it would free up the court to kind of start where it makes the most sense. And in a case where the trial goes to, or the case goes to trial on the merits, the most sensible place to start would be at the end to say, was there a jury question here? Did this go to trial? We aren't dealing with a case that was dismissed on a directed verdict or summary judgment, because if we start there, then that kind of alleviates the need to look at this issue of probable cause for filing.
Looking at the restatement third, it says probable cause exists when, comma, at the time of instituting the proceeding, comma, there was evidence that would lead a reasonable person properly informed and advised to conclude that there was a substantial likelihood that their challenge would be successful. So that indicates maybe we don't even look at the end, we just look early on whether it was there.
I agree, and I've puzzled over that restatement section, but my response to the court would be, how do you know what you know when you file? Good place to look is what evidence came in, and to do that, you're looking at the trial, right? Like, if you allege facts in a petition, and we assume that a case, that a no contest clause is being enforced, that means that the will was in fact challenged and lost. The challenger lost, right? Because if the challenger wins, it's out the window. There's no will.
There are a lot of cases out there that say you look at the time the will contest is filed at the front end.
I'm not disagreeing with that. I think that's correct. But what I've struggled with is understanding, particularly given the Workman 2017 Court of Appeals Workman case that says merely filing a lawsuit isn't evidence of good faith or probable cause. Well, if we're not going to accept just the mere filing of it, then how do we determine if the filing is in fact rich with probable cause? Well, if you go to trial and you survive a directed verdict and the district court says, I see evidence here of a potential jury verdict for the challenger.
Should we put on the denial of a directed verdict for Karen? I mean, because we've recently encouraged our judges and reminded them of the Uhlenhop rule, close cases, just let it go to the jury. So should it be a factor we consider?
Why I think a totality of the circumstances would be better in this case. We're not, yes, it should be a factor. It should not be a deciding factor. I think it's informative in then going back and looking at what did you know when you filed. The problem I have with the restatement and the thorny issue of this advice of counsel and whether that was given, it's our position, petitions only contain facts that were given to the lawyer by the client. And so if that petition survives summary judgment, survives directed verdict, whether we're assuming again that the challenger lost, but the facts were in fact well pled and there was evidence to support those facts. Now,
question is, I didn't see it clearly expressed in our older precedent. Who has the burden of proof? Does Kathy to prove that at the time of, or that she did act in good faith and with probable cause, or is it Karen's burden to disprove that?
I don't see a clear answer either. I would think that it would be Kathy's burden to show that, particularly since the case law seems to focus on what did you plead, what did you know. So I think the burden would be on Kathy, but to that point, I also get confused over probable cause and good faith, and Workman talks about whether those are interchangeable or if both are necessary. Again, the benefit of taking a totality of the circumstances approach would be occasionally you might need to look at good faith in situations where you have a disgruntled sibling who has challenged prior inter vivos transfers and lost, but still had quote unquote probable cause because the parent was not well, not healthy, and then challenges the will. Then you might want to look under totality of the circumstances, is this good faith? I don't think good faith necessarily comes into play in Kathy's case. Or
In this context, be a subjective test?
well, that's another thing that Workman talks about is how do you define good faith. It revolves on a continuum of objective to subjective. I think
Objective, so if good faith is also objective, then it's kind of redundant, so it seems like it ought to be subjective, but.
discusses that as well, talking about how the subjective good faith would be objectively reasonable or not, which is again why I think rigid elements of a test to whether or not a no contest clause should be enforced is very tricky. And looking instead at a totality of the circumstances is a better way to truly evaluate whether the no contest clause should be enforced.
Trial-related rulings, which I'll just be candid with you. The denial of a directed verdict to me is probative of nothing, given that we've basically instructed our district court judges to deny directed verdict in any event. So what evidence would be probative to show probable cause at the time she filed the suit, independent of the denial of summary judgment, denial of directed verdict?
The evidence presented at trial itself.
Facts here in your mind that carry this burden?
Okay, thank you. So it was alleged in the petition that that Ms. Hoffman, Karen's sister, Kathy's sister, had been telling Rex, their father, that Kathy was stealing from him. It was pled in the petition that Rex suffered from paranoia. He was a war veteran. And at trial, we had a written letter from Karen to Rex stating just that. Kathy's stealing from you. Don't trust Kathy. Kathy's a liar. And Ms. Hoffman admitted under oath that those things were not true. And so if we look at what Kathy knew at the time of filing, she knew that her sister was trying to influence her father against her, and that turned out to be true. Moreover,
You knew, what is the evidence in the record about what she knew about the prior wills that Rex had created? The attorney, Coakley, I think was his name, testified that that Rex had changed his will quite a bit. Is there any evidence in the record about what Kathy knew about any of those prior wills?
remember correctly, there was evidence that Rex had drafted quite a few different versions, but I think executed prior wills were not as frequent. But the question was, what did Kathy know about that? I don't believe Kathy knew the extent of visits that Rex had to Mr. Coakley, but it was certainly in evidence that from both Kathy and Kenny, her brother, that the intent of the family throughout their lifetime was that the estate would be split equally.
Prior will in the record that had an equal split?
Equal split?
Yeah, or roughly, are there any prior wills in the record?
Believe so, unless I'm forgetting. And why that's not in the record, I couldn't tell you as I stand here today. But it sounds like we're talking about a totality of the circumstances approach, whether or not there was an awareness of a present will. Again, I would argue in this case, the circumstances more relevant are the will that was in fact probated was signed 19 days before he passed, which is cited often in many probate cases involving will contests, that the will was executed very shortly before the.
Aware of the medical opinion by his family doctor that he basically it was of sound mind or passed cognitive tests? Or?
No, so Kathy was not at that point welcome in Rex's doctor's appointments, and the appointment that Mr. Coakley had set up was not known to Kathy. Now, but this again gets into the fun discussion of, well, does Kathy need to know absolutely everything about her father's life in order to be entitled to survive, to one, challenge the will, and then not be punished for challenging it, when what she does know is that her father's getting older, her father died? Does she need to know everything? Obviously, no litigant in the civil world is ever going to know everything. Everybody's going to have their own side of the story. And so under a totality of the circumstances approach, do we punish or discourage people like Kathy who know, based on the pleading, my sister's trying to convince my dad not to reward me in his will? Do we punish those people? And I think the answer is clearly no. One thing that.
Yeah.
So there are strong public policy considerations that the case law cites for allowing people to contest the will, to provide the fact finder with a more complete view, not view, but understanding of the circumstances and facts leading up to the execution of the will. Because public policy, the courts have a very vested interest in knowing that the will submitted and probated and property disposed of by law is in fact the will of the testator.
Sorry. How do you compare or balance that against the other public policy of testators being allowed to put in their will, I don't want anyone to fight over my will, and so this is the purpose of having a no contest provision?
The two countervailing public policy interests. One, absolutely, and I think the district court might have been going for this in its short ruling enforcing the provision where he says the evidence shows Rex wanted harmony among his children. And there's a good public policy reason for allowing no contest provisions, and we're not here to say that they aren't enforceable. There is a reason to allow those provisions to be enforced, but there's also a reason to allow those provisions to be tested. Most often what we see is that the person who, well, I shouldn't say most often, but certainly bad actors who might influence a testator might also influence them to put in a no contest clause because, well, that raises the stakes. I think this case is fascinating, not because we also have Mr. Kenny Felten, who also challenged the will, but he takes nothing under the will. So what's the risk to him to challenging it? Kathy bore the risk alone in this case because she took under the will, or should have.
So the restatement third says advice of counsel is a factor. Should we expect the party with the burden of proof, once their jury trial was unsuccessful, to have the lawyer testify or at least have the challenger testify about what legal advice she has?
I've noodled over that in getting ready for this, and to be honest, I can't figure out how it's helpful. It suggests two things to me. One, it suggests that in this case, Kathy, would be saying, I have an equitable argument as to why to not apply this no contest to me. It's because I didn't understand that if I challenged it, I would be barred. That's one. Two, it seems to imply that there's been some new or novel or unique theory of recovery advanced that the lawyer needs to testify, here's why I told the client to do this. These will contests, they aren't new theories of recovery. They're pretty well worn. And so I would urge the court to, if advice of an attorney is going to be a factor, and I could see how it could be a factor, I think contrary to Workman, the fact that a petition was filed with well-pled facts that was tried on the merits should be sufficient to satisfy an inquiry as to whether or not the client conferred with the attorney and provided the attorney with facts sufficient to bring the case in the first place.
You can wrap up in a little bit. Your time is actually growing. It's a conceiving light. Yeah, deceiving, I should say, deceiving.
Thank you.
Ms. Hess.
Good afternoon. May it please the court, counsel? I'm here this afternoon on behalf of the estate of Rex Felten and Karen Hoffman, the executor. Before I address some of the appellant's arguments, I want to remind the court that I'm really here on behalf of the Rex Felten estate, and I want to uphold the district court's decision enforcing the interim clause, because that is what Rex Felten's wishes were, and that's what he expected under Iowa law when he made his estate plan. The unique facts and circumstances in this case, and the way in which Rex carefully made his estate plan and deliberately and thoughtfully went about it, should be taken into consideration by this court. So the appellant is here asking you to adopt a totality of the circumstances test, when the Geisinger standard is workable. And why is that? We want to keep that test, that dual standard of good faith and probable cause at the time of filing. We want to make sure that there is probable cause for these will contests.
You about the at the time of filing. Say you have a situation where one sibling is completely cut out, so they have no idea what the medical, they know that their parent is failing, but they don't have access to the medical records. Maybe they don't have access to the parent. How are they going to know that other than through discovery?
Well, they have to have some facts to come forward. So in order to file a will contest, you do have to have some facts to plead. Just because you're unhappy with the inheritance you received.
Agreed, but it seems like that if we're going to look only at what was known at the time of filing, then it's pretty easy to cut somebody out of a will if you get them away from the parent, convince the parent to change their will, and then put in a no contest clause. And then if they don't know anything, they don't know anything if we're only looking at the time of the filing.
Dual standard of probable cause and good faith. So under the good faith standard, if it's brought for proper motivation, truth-seeking, not leverage. So under Geisinger, if you look to Geisinger, the good faith standard allows that gatekeeping to bring a valid will challenge. That's why we have to keep Geisinger as our standard in Iowa.
Weight should we give, if any, to the district court's summary judgment ruling dismissing Karen's abusive process counterclaim?
Applies because an abusive process has different elements that the plaintiff would have had to prove that don't really apply to any of the elements in the will contest.
A factual question, in the record, was Kathy aware of the medical opinion before she filed the will contest?
Actually get to that next. What was Kathy aware of? We know that Kathy lived with Rex for 10 to 12 years, up until 2019. We know that she took him, and this is all developed in the trial record. We know that Kathy took Rex to his doctor appointments. Dr. Thompson testified that Kathy brought him to her appointments. We know that Kathy,
Don't we also know that during this time, she was apparently going to be getting an equal share while she was living with them?
she was what?
Equal share? Was that in the record?
There was never any will put into evidence that indicated that, but we do know that Kathy was on disability. Kathy and Rex discussed that Rex wanted to preserve her ability to receive disability benefits and not have any inheritance disqualify her. That's in the trial record that her and Rex had that discussion. And she was unhappy about that.
Ruling, we're dismissing the counterclaim. The court talks about the parties agreed that the new will, rather than dispersing all the property evenly between the three children as in the old, left nearly the whole estate to Karen. Do you know what the basis is for that factual statement in that ruling?
I don't right now. I believe it was something in discovery, but I don't.
I was going to, and looking at the ruling, mentioned previously equal shares.
Yeah, I don't know what document that was, but I think it was.
Discussion that when Kathy was living with her dad for 10 to 12 years, that there was a will with equal shares. Does that change what you have to say?
I think if you look at the discussions that Rex had with his attorney, his growing concern with how Kathy treated him that had nothing to do with Karen. Kathy removed antiques from his home, which he was unhappy about. His attorney, Attorney Coakley, testified about that. His relationship with Kathy deteriorated, not due to anything Karen was doing. He didn't go.
She wrote that she admitted she wrote, how can you say that had nothing to do with it?
No evidence in the record that that influenced Rex's decision on his estate planning. Attorney Coakley testified that there was his opinion was that that didn't influence his estate plan. He was specifically asked that during trial.
Influenced. It doesn't go to whether or not Kathy was exercising good faith and had probable cause for bringing the challenge.
Well, it goes back to what Kathy knew when she filed this. And she knew she had been going to his doctor appointments. She had been going to his attorney appointments. So when she met with her attorney and wanted to file this will challenge, her attorney could have called Attorney Coakley and could have had a discussion with him, could have gotten the physician letter, could have discussed with Attorney Coakley whether there was any undue influence when that will was executed. No discussion with Attorney Coakley until the trial when he was cross-examined. There was no good faith effort on the part of on Kathy's part or her attorneys to investigate this claim. Forfeiture applied to her in this case. That's why the appellant wants you to adopt a different standard.
We keep the attorney advice prong of the Geisinger case.
The attorney advice as a factor? I don't think the attorney advice should be a factor. I mean, that was in a Court of Appeals decision that I don't believe that should be a factor. And one of the other issues I wanted to address is kind of the timing on when the court considers the probable cause and good faith factors. Now, in this case, the appellant was afforded an opportunity at the hearing on the final report to put evidence on as to what her probable cause and good faith basis was. And they failed to put any evidence on. The record is devoid at the hearing on the final report of any evidence of probable cause and good faith. So not only do we have a jury verdict for the defense, but the record is completely devoid of any attempt to show the court evidence of probable cause and good faith.
These attorneys' professional statement that he would, even having gone through the trial, he would tell her to do the same thing based on the evidence.
It's based on, there's no evidence that he based that on.
He made a professional statement, say he put in an affidavit, that very same thing. Would that be something to consider?
I don't believe it was in an affidavit, it was in his brief.
Thought he made a professional statement at the time that the district court was considering the separate issue.
Like I said, I don't believe that the Court of Appeals decision, including that factor, should be a factor that the court should consider for probable cause and good faith.
Review.
Geisinger, I think we should follow Geisinger, probable cause and good faith.
In terms of the finding of fact on probable cause and good faith, what is our standard of appellate review of that decision?
Errors at law? Yes, this is de novo, yes.
Judge Werling sat through the entire jury trial, so he had a front row seat for that evidence. Should we give weight to his credibility findings on the hearing on objections?
Yep. He was the same, the trial judge also did the hearing on the final report. So he would have also been able to judge the credibility of any witness that may have testified at that hearing, but there was no evidence put on, no one testified. They were given an opportunity to show probable cause and good faith, and there was just none shown. The record is devoid of any evidence.
Standard of review question. So we've had posited it's correction of errors at law, which would be deference to the district court's findings, or de novo. Which one do you think it is, and what case stands for that proposition? Because I thought it was correction of errors at law.
Well, the record would be reviewed de novo. I think in both instances, it's the trial court. So if the case goes to trial, I believe the appellate record would review the entire trial court and the hearing on the final report. So it would be de novo.
I think deference, I mean, is it substantial evidence review, although we're reviewing the whole record? Or do we make all the credibility determinations on our own de novo?
I think the credibility determinations should be left up to the district court judge.
What role your brief refers to stare decisis. Can you address how that comes into play to help us today?
Decision? Yeah. I think the Geisinger decision, even though it's from 1950, is still good law and should be the standard that the court continues to follow.
The challenger needs to show both good faith and probable cause. And in that case, Geisinger court seemed to rely on the advice of counsel as a factor. Should we keep that?
Yeah, under Geisinger, though, it was a little bit different. The advice of counsel was at the time of filing.
We have a lot of pro se. Does it make sense to keep that in there as part of our test?
Challenges.
Is that going to, I mean, you're saying if you don't hire a lawyer, you can't ever satisfy this test?
One of the factors. So probable cause is evidence that would lead a reasonable person, properly informed, to conclude that there's substantial likelihood of success. So you don't need an attorney for that. And then proper motivation is truth-seeking, not leverage. So I think that even a pro se person can meet the test whether or not they have an attorney or not, that they can still investigate those facts on their own without an attorney.
Burden of proof should be on Kathy to show good faith and probable cause.
I'm running a little bit out of time, but the Workman case, although not controlling, cites to Womble versus Gunter, which is a Virginia case, and that indicates that the person challenging the no contest clause has the burden.
Says that we should consider how long the jury deliberates. I'm not sure if I know of another circumstance where we would.
Factors that Workman talks about, and in this case, the jury got the case at around 3:30 in the afternoon, and they brought back a verdict around 5 p.m. So I don't know how much of a factor that has on the case. I think overwhelming evidence, would show, a quick verdict would prove overwhelming evidence that a jury doesn't take that long to make a decision. So again, in this case, the appellant at the trial court brought witnesses that were all had an interest in the case. The executor brought in witnesses that had no interest in the case, were people that were Mr. Felton's attorney, longtime attorney, treating physician, and the weight of the evidence shows that the interim clause should be upheld, and we ask that the court affirm the district court's ruling. Thank you.
Mr. Arato.
So to clarify, we aren't stating that the standard has to be changed. We're suggesting that a more defined test and more easily workable test is appropriate. However, jury deliberations did come up in the Coughlin case from, I think it was prior to Geisinger, because Geisinger cites to it. And I would strongly urge the court to abandon any kind of jury deliberation time as a factor in determining whether good faith and probable cause exists.
The procedure of the case. So the final report disallowed Kenneth and Kathy from taking under the will because of the no contest provision. And then there was an objection to that, saying there was probable cause and good faith. And then the parties agreed that the judge would just make a ruling, correct?
Yes, so initially, we actually continued the hearing so that the original judge who heard the case, the trial, would be the judge hearing the objection. And I think that's actually referenced in the district court's ruling, a quick sentence about having heard the trial evidence. So yes, that's essentially what happened.
Argument on the issue, but no presentation of evidence, correct? Okay.
I had already lost the case once, right? Didn't want to try the case again, basically to the same judge with the same evidence that we had already presented.
Necessarily the case that the trial on the motion to enforce, or the hearing on the motion to enforce the no contest clause might not be the same, right? There might be testimony about what diligence your client did before filing the suit. Even if some of that didn't make it into the trial record, she might be willing to waive attorney-client privilege and say, here's the information I received, here's an opinion letter. It seems to me they're two totally different issues, so I don't know why the trial record is necessarily probative of what she knew at the time she filed suit.
Under the facts of this case, I would argue that it's because we had evidence for what we pled in the petition. I would certainly agree the attorney-client privilege belongs to the client, and if they choose to waive it, they can do so. Whether or not it was necessary in this case, again, maybe adopting a totality of the circumstances, it sometimes can be useful, but I don't think it's necessary. I think it could be a factor if the challenger who lost decides that they want to get another chance to explain to the court why they did what they did, if the writing wasn't on the wall with a letter from the sister. And
You agree under our case law, it is her burden to, the presumption is when, once you've gone through trial and there's no undue influence, et cetera, that the policy then is to enforce the will as written to effectuate the testator's intent.
I would disagree. I think the policy is enforce the will as written except for the no contest clause if there's good faith and probable cause.
Which is a fact finding based on evidence relevant to the question of what she knew at the time she filed suit, and you chose not to put on any evidence on that issue.
I would say I wouldn't have any additional evidence other than what we presented, which was, again, I don't think I need to repeat that part. This issue of attorney advice, again, probable cause, and to her Honor's inquiry about pro se litigants, I think that's another issue where it demonstrates the limited effectiveness of the current test and the rigidness of it, and adopting a more totality of the circumstances approach could be beneficial. I have a few seconds left. I don't have much of substance to say, other than I've gone over and over the restatement provisions, suggesting that advice of an attorney can be a factor, and all I can think is that it is potentially from a time when
Fact pattern. So probable cause, as we've defined it in this context, is different than criminal. And there has to be some sort of belief of a substantial likelihood of success on the merits of the undue influence claim, correct?
claim you're bringing. Yes, okay.
So what if the attorney opinion letter says, you have a claim here, you allege some facts, we can assert it in good faith, but in my professional opinion, it is highly likely that you will lose. Not only that, you don't have a substantial likelihood of winning, you almost have zero chance of winning, but under my ethical obligations, I can bring this suit in good faith, even though you're likely going to lose. There are all kinds of lawsuits that people bring that are very likely to lose, but they're ethically brought and they're brought in good faith. I mean, why wouldn't that be relevant on the issue?
Such a situation, I couldn't make my client waive attorney-client privilege, and I couldn't give that letter over.
Right? I mean, or if they had the opposite, an attorney letter that said you are very likely to succeed on the merits, that would seem to be relevant to the issue.
But I mean, not to make it about me, but the attorney is no guarantor of success or failure. We give advice. Personally, I always say, going to trial is a risk. Anything can happen. And as I mentioned in the filing, I would take this case to trial again. We lost it, but that happens. But we are not here to be guarantors of success or failure. And it doesn't seem like a litigant should lose out on potential inheritance. Maybe they got bad advice from the attorney. Well, my attorney told me to do it. I don't think that's a good standard. I don't think it needs to be applied. Go ahead.
Question. I mean, if the number one policy reason it seemed like that was given in your favor is sort of the truth-telling aspect, right? That this aspect of that the court ought to have access to the truth. Although I suppose if there'd been no contest about the will, the court would have learned nothing, right? But I mean, like to Justice McDonald's point, I mean, if we're saying truth is the important issue, I think it would not be crazy to say it would be okay to put clients in a situation where they need to decide if they want to possibly waive the attorney-client privilege, if they want to go forward, because that would also be advancing that truth-telling and truth-gathering process.
I would point out that the petition was verified, which I think assists the court in a decision of whether or not good faith probable cause existed. It's, a lot of civil lawsuits aren't verified by the client, but this one was and required to be so. We are here talking about fairness, though, right? So, I mean, if it's fair to require a person challenging their parent's will to agree that they're going to have to waive attorney-client privilege potentially, that's a tough standard, and I would urge the court not to adopt that. I'm over time, unless anyone else.
Okay, the case of Estate of Felten is hereby submitted, and court is adjourned for the afternoon.